Our second matter before us this evening is the Substantive Validity Challenge to the Municipality of Murrysville Code of Ordinances, Section 2031CC. At this point, I'll turn the hearing over to the zoning hearing board solicitor, Mr. Larry Lopez.
Thank you, Madam Chair. I'm going to read a statement into the record. The zoning hearing board of the municipality of Murrysville, Westmoreland County, Pennsylvania, will conduct a public hearing commencing on Thursday, November 29, 2018, at 7 o'clock p.m. at the Murrysville Municipal Building, 4100 Sardis Road, Murrysville, 15668, to receive testimony, evidence, and public comment regarding validity challenge to the municipality code, section 220-31CC, as filed by the Murrysville Watch Committee, Dominique Ponko, Barbara Sims, Deborah Borovic, Joe Evans, Judy Evans, Susan Stewart Bain, and Jean Martin, members, as associated with the placement of a well site on Ballinger Road, approximately 2.5 miles west of Kemmerer Road and Ballinger Road within the municipality of Murrysville. Said property is situated within the New England Gas Recovery District. Article 5, 221-31 of the Code of Ordinances, as amended in 2011 as a result of the enactment of Murrysville Ordinance 833-11 and further amended by Ordinance 930-15, again codified in the Murrysville Code of Ordinances under section 220-31CC. Before we begin the proceedings tonight, I have a few general matters to discuss with all the parties and visitors to the proceeding. The Murrysville Zoning Hearing Board conducts what is called a quasi-judicial hearing. This is quite different than a supervisor's hearing or a town hall meeting where people will stand up and speak. This is more of a court proceeding because we have a court reporter present and she is taking down all of the testimony that will be directed by everyone's respective attorneys here tonight. As the proceedings go on and as we go further into this, there may be individuals at the end of the testimony that will want to give public comment and the board will open it up for that purpose. But that may be a couple of hearings down the road because we anticipate that there is going to be substantial testimony. So a few matters of decorum. Because this is going to be treated like a courtroom situation, we would ask everyone to refrain from outbursts or if you're not happy with the testimony, saying anything. You will have an opportunity through your attorneys or in a public comment phase to make your comments. But we try to avoid anything that's going to be an outburst or it's going to be disruptive to the process. This has never happened to me in my 20 plus years of practice, but in the event that we do have an outburst or something that is very disruptive, the chairperson can put people out of the room tonight. We would prefer that that not happen in any of these proceedings. With that said, I would ask all of the parties through their legal counsel to identify themselves on the record, who they represent. I'll ask the appellant to proceed first, of course. After the parties have entered their appearance, the zoning hearing board will ask for opening statements. These are not evidence, but they will help outline the position of each party. When you enter your appearance on the record, please advise if you are an intervener and are requesting the board to recognize you as an intervener for these proceedings as well. Mr. Smith?
Would you like me, counsel, to identify my clients, or do you want them, if they're here, to stand up?
You can do so. I'm fine with that.
As the caption that we filed indicates, first of all, my name is John Smith, and I'm counsel for a number of individuals that make up an incorporation of what's called the Murrysville Watch Committee, a Pennsylvania corporation. Dominique Ponko is a member, Barbara Sims, Deborah Borowick, B-O-R-O-W-I-E-C, Joe Evans, Judy Evans, Susan Stewart Bain, and Jean Martin as members of that organization. Dennis Skiers is the president of that organization as well.
Thank you. Who speaks for Murrysville tonight?
My name is Bill Siddig, and I'm representing the municipality of Murrysville.
Good evening. My name is Blaine Lucas. I'm here on behalf of Huntley & Huntley Energy Exploration, LLC. We desire to intervene in this matter, and I have a letter to that effect, entering my appearance and that of Paul Burke, Vice President and General Counsel for Huntley.
If there's no objection, we'll mark that as Board Exhibit 1 and enter it into the record.
That's fine, and we have no objection to the intervention.
Thank you.
Good evening, my name is Bernie Matthews, and I represent several landowners that wish to intervene. My clients are David and Cindy Giswali, Douglas and David Geiger, Barry and Pamela Paulsick, and Free Gospel Church, Inc. Each of these properties has leasehold interests in Murrysville through Huntley and Huntley. 3 of these properties are directly affected by the Titan well pad and have interest in that proceeding. And I also prepared a letter to the board requesting permission for these parties to intervene.
I'll ask the Board to accept that as Board Exhibit 2. I'm going to have to get all these exhibits. Board accept all of the notices of intervention in this matter, and if the board has no initial comments, then we can ask Mr. Smith to move forward with a statement.
Before we proceed, I did the courtesy to Mr. Lucas of not objecting to intervention. Same with Mr. Matthews. We have no objection to the intervention of those individuals.
Thank you.
Madam Chairman, if it's pleases the board, I put together a PowerPoint to explain this challenge from a legal standpoint, from an opening statement standpoint. I have physical copies that I'm going to do our best to put it up here on the overhead as well. But Council, or Madam Chairman, if it would be okay if we could at least circulate the hand copy too as well. We have some for council here as well.
We get it on the screens in front of us.
You're going to also get it on the screen if everything works well? But if the hand comes back, the copies come back.
I think they handed her these sorts of intervention.
One numbers, or you do letters and numbers, just for reference purposes, or any preference?
We'll make this appellant's A.
Okay.
That's,
And I guess lastly, from a housekeeping standpoint, so I'm not in front of anybody, would it be okay if I sat for a while? Okay. I'll move quickly. I know your time's valuable. And the purpose of this PowerPoint and the purpose of this opening statement is to explain to the zoning hearing board a little bit about the overall challenge. I understand there's a lot of different issues, a lot of moving parts to this challenge in terms of it's just not this violates X or Y. This violates a number of different provisions that we plan on presenting to this board tonight. I think there's an agreement amongst council due to the time constraints. We're going to try to just do opening statements and maybe have a preliminary motion argument later, so we're not going to get into the actual introduction of evidence through witnesses. But to understand our case, to understand the witnesses, to understand the questions that we're going to pose, I believe there has to be some legal backdrop to that, some legal understanding of not only what happened in Murrysville, but what happened to the state of the law during this time period, so that this board appreciates the legal arguments going forward. Some of these we're going to move quickly. Luckily, we had on the first page there the caption, so I can tell you all the individual parties and the spelling of their names. But here, under a substantive validity challenge, a standard review this board should be well aware of, but I bring the board's attention to the language of the party challenging the validity of the provisions of the zoning ordinance must establish that they are arbitrary and unreasonable and have no substantial relationship to promoting the public health, safety, and welfare. That is one of the driving arguments that you'll hear not only in my opening statement, but throughout this process, that this ordinance was not drafted that serves to protect the public health, safety, and welfare of Murrysville residents. This is not a presentation about whether you're pro or anti-gas. That's not the issue before this board. This is, did the board follow its legal guarding functions in promoting and adopting the ordinances in question? So the overriding issue here, and you'll see it in different veins, is did they act arbitrary and did they protect the public health, safety, and welfare? And for you to listen throughout this process, you ask yourself and ask the municipality, if they did, how did they do it? This is a summary of the various items that we drafted in this challenge. These mirror a lot of the Supreme Court precedent that's come down from 2013 through 2018. Violation of Article 1, Section 1 of the Pennsylvania Constitution and the 5th and 14th Amendments to the United States Constitution by inserting an industrial land use into their rural residential district by overlay. That deprives members that live in that area, some of which are my clients, of substantive due process and quiet enjoyment. A lot of legal words there that will be explained as we go on, either tonight and through the hearing. Violations of 604, 605, and 606 of the MPC that essentially municipalities have to protect the public health, safety, and provisions of safe water supply and not providing uniform uses within zoning districts. Next is violation of Article 1, Section 27 of the Pennsylvania Constitution by failing to account for the rights of citizens to clean air, pure water, and the preservation of natural aesthetic values of the environment. Next is the violation of Article 3, Section 32 of the Pennsylvania Constitution by creating special legislation to favor a particular industry. And lastly, violation of Murrysville Comprehensive Plan by creating an overlay district that disturbs the expectations created by the underlying district, that being the rural residential. Now, there's a lot there, but again, I will walk through some of the case law that explains this as we go forward here. Just a little background of how we got here from Murrysville's standpoint. Prior to 2009, most municipalities that we all represented were under the assumption that oil and gas was preempted by the state, meaning that local governments couldn't do anything. We were preempted, and most municipalities did not have local regulations that dealt with oil and gas. It just wasn't on the book. Oakmont, one of your neighbors out this side of the world, changed all that. So here we have this perfect storm. Marcellus coming of age, 2005, 2006, 2007, and now we have a situation where municipalities are looking at this, saying, how do we regulate, can we regulate unconventional drilling? The case of Huntley and Huntley versus Borough Council of Borough of Oakmont decided that question. There, the Pennsylvania Supreme Court in 2009 found that state regulations as to how drilling takes place, the technical aspects of drilling, do not speak to zoning. Those are different animals. And that it wasn't specific in the state law that the state could preempt local municipalities' functions to create zoning districts that protected people. So now everybody was off to the races, including Murrysville. Everyone had the green light that they could now draft ordinances, and Murrysville was no different. After that decision was the Pennico case, which is cited here. And what's important about this is you'll also hear, I believe, from the municipality that a lot of their duties that they believe that are related to the public health and safety, or that are related to the right to clean air and pure water, are the DEP of the state's province, which is opposite of what I just told you. That issue has been up multiple times, and multiple times the Supreme Court has said, no, they are different. You have different roles. The state has a role, the local government has a role. In the Pennico case, of importance was the fact that is the following language. As such, the limited provisions of the zoning ordinance governing oil and gas wells in Fayette County do not accomplish the same purposes set forth in 102 of the Act 5861-102, which was the then Oil and Gas Act. So they allowed that ordinance to stay because they accomplished different things. And again, when you listen throughout this case, you'll listen to Murrysville setting things based on what the state has done, and the court saying what the state has done is a different obligation than Murrysville has to its residents. Now, on this timeline I put together, and I believe, because I haven't seen anything prior, but in 2009, again prior to Huntley, Murrysville, most likely like all municipalities, not only thought they were preempted, there really wasn't a need to regulate oil and gas because Marcellus wasn't here. Nobody was worried about 50-acre drill sites, and multiple big industrial uses until later. In 2011, after the Huntley, Murrysville now adopts their first oil and gas ordinance to regulate this. Murrysville allows 33% of the municipality to be available for unconventional drilling and creates the overlay district. Again, during this time period, we don't necessarily look at Murrysville at fault here. They did the best they could in an area that was kind of questionable after the Supreme Court ruled and before we get to the Robinson case. In 2012, Murrysville's victory in ordinance was short-lived when the Pennsylvania legislature adopted Act 13. Act 13 preempted everybody, including Murrysville, and it said that you had to allow unconventional drilling in every single zoning district as a matter of law as a permitted use. So I think their ordinance was just a few months old. That was adopted and signed by Governor Corbett on February 14, 2012. Thereafter, before Murrysville was preempted, there was an injunction issued. So we went to court, we got an injunction. The court stayed the application of Act 13. Went to court in the summer of 2012. The Commonwealth Court ruled that Act 13 that allowed drilling in all zoning districts was unconstitutional. Struck it down. That case went forward to the Pennsylvania Supreme Court, and we received a decision in December of 2013 that affirmed the Commonwealth Court, albeit on different grounds. They found that it was unconstitutional and violative of Article 1, Section 27 of the Constitution. Now that that issue is resolved, Murrysville moved forward, and now we're looking at a new comprehensive plan. I won't know until the testimony comes out, but I believe, based on the fact that comprehensive plans happen every 10 years, that in 2011, that this zoning district, this overlay district that allowed 33% was not consistent with the comprehensive plan that would have been made years earlier, at a time where they thought they were preempted and weren't planning for oil and gas extraction. But they had a task force, the plan was adopted, and Murrysville enacted the ordinance in question now that encompasses the 2011. They kept the overlay district, kept the exact districts in place, and they adopted additional regulations. Now, the next slide is somewhat out of place, except that it goes to this idea that you have to understand where we came from to understand what obligations municipalities have, not just Murrysville, all of them. In Act 13, there was a section titled Section 3303. And essentially, what this section did was, notwithstanding any law, it preempted local governments from enacting any regulations that dealt with environmental laws. Basically said that the state is going to handle environmental laws, similar to what Murrysville refers to in that deferring to the state, that that's their province, they're going to handle it. If you look here, the court struck that down as unconstitutional. The reason it was unconstitutional was that local governments have an obligation to regulate and protect environmental interests under the Pennsylvania Constitution. So the fact that the state tried to once again stop local governments, including Murrysville, they were struck down as unconstitutional. If you look at the next one, this was the zoning portion, Section 3304. 3304 was already alluded to, spoke to the idea that governments like Murrysville had to enact local regulations that permitted drilling in all zoning districts. Murrysville never had to do that because of the injunction. And I will tell you, throughout the process, when we challenged Act 13, Murrysville assisted us at the Supreme Court level in making sure that their ordinances could stay in place and that they weren't stuck with a drilling in all districts. And we'll get to that later. That, again, was declared unconstitutional, and I'll get into the reason why in a minute. Now, if you look at the 2011 Statement of Purpose, when they drafted their ordinance, Murrysville said the purpose of this subsection is to provide the health, safety, and welfare of the residents and their property in the municipality of Murrysville, to facilitate beneficial compatible land use. They created this oil and gas recovery district in the RR rural residential area. Again, ultimately, we take issue with two things. One, that it was not done consistent with the health, safety, and welfare. It was done to, as you'll hear, to make sure they weren't sued by the oil and gas industry, and to make sure that people could drill in these particular areas. Not to protect the public health, safety, and welfare, and that these uses were not compatible with existing land uses in the municipality. Here, we'll flip through this rather quick. This was just the comprehensive plan under Pennsylvania law that required every 10 years that Murrysville follows. And if we go to the next slide, this was their comprehensive plan that was adopted, a portion of it, under the Energy Resources in 2015, prior to the 2017 amendment, but after the Robinson decision. What's important is an acknowledgement here by Murrysville of the comprehensive plan. The Pennsylvania Supreme Court has recently ruled that Pennsylvania municipalities have the right, under the provisions of the Pennsylvania Municipalities Code, to use their comprehensive plan and their zoning powers to regulate the location of oil and gas drilling well sites, as well as establish standards to protect the public health safety under the provisions of the Pennsylvania Constitution's Environmental Rights Amendment. Accordingly, the municipality needs to review its current zoning regulations on oil and gas drilling to assure, as a primary objective, that the public health, safety, and welfare is protected to the maximum extent possible through its authority under Pennsylvania law. You will see that this ordinance does not come close to the comprehensive plan in protecting to the maximum extent possible, in that Murrysville doesn't really know whether or not the public health, safety, and welfare will be affected by anybody living near these drill sites, based on the information that they received during the public hearings. Here, again, with the MPC, just some housekeeping matters. It's supposed to reflect the policy goals of the municipality. And if we flip to now the rural residential district. So this is the district that the municipality of Murrysville looked at to say this is where we think drilling should go. The problem that Murrysville had is a problem that a lot of municipalities that are built up have, that you already exist. Murrysville created residential, commercial, business. They have all these separate districts that are already in place based on their prior comprehensive plan. And now they have to infuse operations of unconventional drilling. Where are they going to put it? So this industrial use, instead of being placed in an industrial zone by district, they zone by parcel, and they try to do by overlay district. But if you look at the purpose of the district, and you look at the purpose of the rural residential district, well before the oil and gas ordinance, well before unconventional drilling, and that my clients face, when they purchase their home, that they can rely on this ordinance that says this is the purpose of this district. It's intended to protect environmentally sensitive areas and portions of the municipality that are not otherwise suitable for development at higher densities. Single-family residential uses on large lots where needs for traffic facilities and utilities are low, and where it is appropriate to reserve the rural atmosphere of the municipality are primary consideration. Now, 33% of the now rural residential district, you can have unconventional drilling industrial uses. The uses not permitted in that district include apartment buildings, daycare centers, fourplex, garden apartments, group care facilities, mobile home parks, and multifamily dwellings and nursing homes. Those are uses that Murrysville said are not compatible with the purpose. They're not compatible with the people that existing that live there. But now industrial drilling, well, they can't have an apartment, they can have a drill site next door. By contrast, the existing business district, the purpose, and through the comprehensive plan, it was to provide areas for the location of commercial and industrial uses in areas of the municipality where infrastructure can support such uses. If you look down at the uses permitted, contracting businesses, garage, light manufacturing, building materials, waste disposal, storage treatment. Those are the types of things contemplated for good planning. Those are the types of things from a compatibility standpoint that you look to and say, where are we going to put industrial drilling? We're going to put it in areas where it's compatible with existing expectations of landowners who have invested and bought property and reliance on the protections that the zoning district provides. If you look to the next slide, the overlay district is one of the issues, and we'll get into this, and I'll just bring it to your attention. The use of the overlay district says two things. One, that rural residential district is not compatible with oil and gas drilling. How do we know that? Because if it was compatible, it would be a conditional use throughout that district. So they have chose winners and losers in the rural residential district by saying some of you that live in rural residential will have this overlay. In this overlay, you should expect heavy industrial use. Others of you that live in the rural residential, you will continue to enjoy the protections afforded you by the purposes of the comprehensive plan and the ordinance. But overlay districts supplement existing zoning districts. They don't supersede them in fact or practice, or they're violative of the law. So your typical overlay that we see that works is you have a residential district, and say you want to be more restrictive and say we want to have a historic district within that residential district. So we overlay a historic district and say within this area, these are going to be historic structures where we can't do X or Y to these. They don't change the underlying district, they provide more protection. This overlay district changes the underlying zoning district to industrial. And again, it's about 33% of the township, or of the municipality as a whole. Now, to understand what the municipality can do is to understand that all zoning is premised on the Constitution. And here, the Pennsylvania Constitution grants broad and flexible police power to enact for the purpose of promoting public health, safety, morals, and the general welfare. But they are limited by the Constitution. Article 1 places a limitation on the state's power to act contrary to these rights. A subject of the right may be amendable. Laws that reasonably impair the rights are unconstitutional. Now, I'm going to run through some of these that I thought were important for you to understand what the basis of this argument is and how zoning works. So, start with the premise that under Article 1, Section 1 of the Pennsylvania Constitution, that you can do with what you want with your property. That's the first thing in the Pennsylvania Constitution from 1776, that hey, residents, you can do what you want with your property. But how then does zoning work? Because zoning restricts what you can do, right? You live in a residential district, you can't become a McDonald's, you can't become a steel mill. So in order to make sure that zoning complies with the mandates of the Constitution, the courts have said, well, you can use your police power. Your police power can be used to protect people. You could create zoning districts that serve to protect people, and those districts protect people if they protect their health, safety, and welfare, and if you only put compatible land uses together. That is why you don't run afoul of Article 1, Section 1 when you zone, because the overarching idea is that you're doing it to protect people. And to understand that, the land use restrictions designate districts in which only compatible uses are allowed and incompatible uses are excluded. These restrictions typically categorize uses as, from the Robinson Township Commonwealth Court, as single-family, residential, multifamily residential, commercial, or industrial. Those are your typical districts. Here, what Murrysville has done is said, we're going to take that industrial district and we're going to go ahead with one use and move it throughout the municipality. Lastly, zoning ordinance segregate industrial districts from residential districts. Murrysville's overlay district does not do that. It doesn't segregate them at all. In fact, it joins them at the hip. The Robinson Township Court found that the interests that justify the exercise of the police power and development of oil and gas operations in zoning are not the same. The basic precept that land use restrictions designate districts in which only compatible uses are allowed and incompatible uses are excluded from the United States Supreme Court. The reason why the court struck down 3304 is it said that allowed the state law to make drilling in all zoning districts. It said it didn't serve the police power purpose of the local zoning ordinance related to consistent and compatible uses in enumerated districts of a comprehensive plan. The same with Murrysville. And it's not in furtherance of the police power, and it was unconstitutional to join them together. On the next page, just the last part, the test of constitutionality of a zoning ordinance is whether the health, safety, moral, or general welfare of the inhabitants of the part of the community affected will be promoted by the applications of the ordinance. And the seminal case of Village of Euclid versus Amber Realty was when the U.S. Supreme Court looked at the issue as to whether you could limit people's uses. So when you think about it, when you live in a residential district and you say I'm R1, what the state or what the local government has said is that's all you can be. You can't be any more than that. And you give up your right to have any other use in exchange for your neighbor giving up the same right. The reciprocity of advantage. You don't have to worry that your neighbor across the street in a residential district will become a bar, will become a cement factory, because you're limited, but you're protected by their limitation. The overlay district changes that, and now my clients are limited to living in their residential district, yet the neighbors can have industrial applications that are incompatible with their current uses. The Pennsylvania Supreme Court found that the constitutional zoning, and why I keep harping on this is that oftentimes the courts and my opposition look to and say, well, we can put in an open field, we can put drilling, don't look at the district, look at the land. It's 200 acres of forest. And the municipality, at any time, can rezone that land and change it to its own use. They could come in and say, let's make that an industrial zone and go through that process. But they typically don't. They typically try to insert drilling into those areas and say, well, because it's wide open, nobody's hurt. But we don't zone by parcel in Pennsylvania. We zone by district. And what the Pennsylvania Supreme Court held is that constitutionally based zoning is the legislative division of a community into areas in each of which only certain designated uses of the land are permitted, so the community may develop in an orderly manner in accordance with a comprehensive plan. Creation of districts which only compatible uses are allowed, incompatible uses are excluded. The rural residential district has now been infused with a use that's not compatible, and it tries to overlay the residential nature of the use that's been in existence. In Robinson Township, the court found that citizens made investment decisions, just much like Murrysville citizens, regarding businesses and homes on the assurance the zoning district would be developed in accordance with a comprehensive plan and would only allow compatible use. That's why the court struck down the state law to require local governments to put drilling in zoning districts that are not compatible with the existing expectations. Now, when we look at this, we do look at spot zoning, because that's when you typically see it. Typically, municipalities don't look at zoning as a constitutional endeavor. They look at it as a public policy endeavor. Where do we want things to go? Let's create these districts. Where do we want things to go? Now, public policy often drives right alongside the constitutional constraints, because people think it's a good idea in a residential district to only have maybe schools, churches, and residential. And cement factories in the middle of those plans make no sense from a policy standpoint, but they also are unconstitutional. Because if you're going to create the district that serves to limit people's rights, that district only remains constitutional so long as compatibility exists in the district. So here, typically when we see this, and in the zoning world, we've never seen it before drilling, is somebody would come to the board and say, we want to put a steel mill in this residential area that's 100 acres in size in the middle of your residential district. And the board would say, we can't do that because you're not compatible. So what do? They say, let's rezone you. Let's rezone that land to industrial. And then let's put that use in that donut and say, this is now the industrial use, because now you're in the zoning district. It's a recognition that the underlying district won't work. You created your new zoning district. You put the industrial use in that district, and life is good. Except when the court says, wait a minute, that's spot zoning. What is spot zoning? You've created this island of use in an otherwise homogeneous R1 district, and they strike it down as unconstitutional. Drilling's the same thing. If you were to put a drill site in that same district, whether you rezoned it or not, the court looked at that and said, well, that's probably not a spot zone in Act 13, nobody rezoned, but it's a spot use. It has the same unconstitutional authority, and they struck it down. Similar to what we have here in Murrysville. Now, if you look at what the Supreme Court did in Robinson, the Supreme Court, in their landmark decision, took a different tack. They didn't look at Article 1, Section 1, in so much as they didn't look at compatibility. The concurring opinion did. The concurring opinion found that the Commonwealth Court's rationale was the one that they should employ, but here for the first time they elevated Article 1, Section 27. And as we've already talked about, Murrysville didn't have this, and most municipalities didn't take this tack until the court ruled in 2013. But the court had a lot to say, our Supreme Court, about fracking operations, finding that fracking operations and exploitation of Marcellus Shale at issue here, the provision compels exposure of otherwise protected areas to environmental and habitat costs associated with this particular industrial use. And please note, the court refers to this properly as a category of industrial use, and so did Murrysville when they adopted the ordinance. The entirely new legal regime alters existing expectations of communities and property owners and substantially diminishes natural and aesthetic values of the local environment. Think back to the definition I put up on rural residential about what the municipality tried to accomplish by that district, and how this statement by the court, why they struck down Act 13 that required Murrysville to put this in that same district, is the same unconstitutional rationale that we would like this board to employ in striking down the current ordinance. Now, there's also, and I threw one more note in here because this has come up through the court's recent decision. Council has made the decision that when we argued Act 13, when we filed that challenge, that we were taking the position that, to the court, that local governments need to zone, and this case is about local government. It was not. We could be local governments preempted all day long by the state. The argument wasn't one of preemption. The argument was, if you're going to preempt us, you can't make us do something that's unconstitutional. It had nothing to do as to we wanted the right. We would have followed the dictates of the state if it was constitutional and they allowed us to place drilling activity into like districts. So here, what the Chief Justice found is that according to the citizens, this dispute is not about municipal power, statutory or otherwise, to develop local policy, but it is instead about compliance with constitutional duties. Unless the Declaration of Rights is to have no meaning, the citizens are correct. Now, the Declaration of Rights is under Article 1 of the Pennsylvania Constitution. And those rights are consistent with the U.S. Bill of Rights, 1 through 10 of the U.S. Constitution. And they are the most essential rights in Pennsylvania. Here, in this case, substantive due process under Article 1, Section 1, and the right to clean air that the court said is the same as your right to free speech, is the same as your right to own a gun. That particular, you can't set it aside no matter what. And because it's a constitution, it applies to local governments as well. Now, as we move forward here to Article 1, Section 27, I've placed the actual text up on the board, that the people have a right to clean air and pure water, and to the preservation of natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. Here, if you look at a recent decision in 2017 from the Pennsylvania Supreme Court, the Supreme Court held that the third clause of Section 27 establishes a public trust, pursuant to which the natural resources are the corpus of the trust, and the Commonwealth is the trustee, the people are the beneficiaries. So in our case, the people of Murrysville are the beneficiaries of the trust. Murrysville is the trustee of their right to clean air, pure water, and the preservation of the natural resources. Now, the court went on in that majority decision last year, saying that there's certain obligations, and one is that the Commonwealth must act affirmatively via legislative action to protect the environment. One of our main arguments here is that this law does not serve to protect the environment in Murrysville, that the information that they relied upon in making this ordinance is lacking, that they didn't do it, that they referred to the state and said if the state's going to let this happen, then it must be okay. And their function is different than the state's, as we talked about before, and their obligations as trustee, they can't rely on the DEP, who doesn't do the same thing as your local government should do. With respect to the public trust, Article 1, Section 27 of the Pennsylvania Constitution names not the General Assembly, but the Commonwealth as trustee. We have explained that as a result, all existing branches and levels of government derive constitutional duties and obligations with respect to the people, which include Murrysville. Now here, as we fast forward to the 2017 ordinance, if you look at the actual ordinance that was passed, Murrysville looked at or set forth a number of whereas clauses. Murrysville found, when they adopted this, that without proper regulation, that oil and gas development may pose hazards to the health, safety, and general welfare of the residents of the municipality. Yet during that process, they never developed the hazards, and they never developed how their regulations would serve to eliminate or keep people from those hazards, only that they exist. The task force looked at a number of things, and number 5 was the methods to protect the public health, safety, and welfare as required under Article 1, Section 27 of the Pennsylvania Constitution. While the municipality recognized their obligation, looking at the ordinance and looking at what they did and didn't do, they did not meet the requirement of making sure that their residents have clean air and pure water. In that, if you put any of their elected officials on the stand and say, who at what distance will be affected by oil and gas operation, I will assure you they will say, I have no idea. And that includes in the next whereas clause about the setbacks. You'll find in this case that the setback started out in Murrysville at 1,600 feet and ended up at 750 feet. It's an arbitrary number. It's not based on science. It's not based on health. It's not based on the protection of people. It's not based on their obligations for people's right to clean air. It was just a number. to that one. Here, under PEDF, the Robinson decision you may hear from council was a plurality, meaning that out of the 7 justices, actually only 6 heard the case, but out of the 6, it was 4-2. 3 found that the law violated Article 1, Section 27. 1 found it violated Article 1, Section 1. So a lot of the arguments that have sprung since 2013 dealt with the fact that the courts and municipalities don't have to follow Robinson because it's a plurality, it's a non-binding decision. But the PEDF court looked at it and said, this is not the first time we have been called upon to address the rights and obligations set forth in the Environmental Rights Amendment. We did so in Robinson Township, and we rely here upon the statement of basic principles thoughtfully developed in that plurality opinion. It's our position that in PEDF, the Pennsylvania Supreme Court now adopted how to deal with Article 1, Section 27. If you look at the next slide, in the Commonwealth Court decision in PEDF, the majority decision quoted the Robinson plurality in that each branch of the government must consider in advance of proceeding the environmental effect of any proposed action. The action here being Murrysville adopting an ordinance that allows for drilling outside of industrial areas at 750 feet from homeowners. What did they look at? Now, looking at this next line of cases, and I'm almost through, so I apologize for the length. But I've heard a lot that the local governments can rely on the DEP. If the DEP issues a permit, then everything's good to go, and that they fulfill their function. In a recent Allegheny Township case, the court seems to follow that model, that there's no real obligation on local governments. And so some of the cases that the court ignored, that I make you aware of, is the Abbey case, the Pennsylvania Commonwealth Court, where the same argument was advanced back then it was DER, but the DEP, the position that the DEP will regulate the facility's operational standards, the appellant's testimony regarding health, safety, and welfare was unnecessary. The court went on and said, we don't agree with that. The fact that a facility will most likely be permitted by DEP does not preclude objectors from introducing testimony that in a particular zoning district, the use in their opinion is contrary to health, safety, and welfare of the neighborhood. The grant of a permit by the DEP is not tantamount to a zoning permit. To hold otherwise would undercut the purpose of the zoning board in reviewing whether proposed use would be contrary to a particular zoning district's citizens' health, safety, and welfare. Moreover, the court went on to say, well, the DEP is empowered to protect the environment. It is not a zoning board. If we were to say that a grant of a permit by the DEP removed all environmental concern from industry to operate in a particular district, we would effectively chill the rights of citizens to come forward with evidence regarding their health, safety, and welfare, and thus would emasculate the purpose of the zoning board to resolve this issue. Now, I won't read the Huntley case, which is next, and even though the Huntley folks are here, but in that case, the court looked at the same argument. Is this preempted? And the Pennsylvania Supreme Court said no. The DEP's role and local government role are different. The DEP actually joined the local governments in finding that their roles are different. While the court said there's some overlap between these goals and the purpose set forth in the Oil and Gas Act, most particularly in the area of protecting public health and safety. As we read the ordinance, the most salient objectives of restriction on oil and gas drilling in residential districts appear to be those pertaining to preserving the character of residential neighborhoods, encouraging beneficial, compatible land uses. In this regard, the highest appellate court of our sister states has observed oil and gas development and land use controls overlap. These core interests and these legitimate government functions are quite distinct. The state's interest in oil and gas development is centered primarily on the efficient production and utilization of natural resources. The county's interest in land use control, in contrast, is one of orderly development and use of land in a manner consistent with local demographic and environmental concerns. They go on to tell you that it's distinctly different. And so Murrysville, to the extent Murrysville relied on the DEP's permitting and obligation, it failed in that regard because there are different roles that they didn't undertake. DEP does not look at whether Murrysville residents are going to be affected, whether their clean air is going to be affected, or whether their health is going to be affected. They're not a health-based body. They don't have the people to do that, and that'll come out during this hearing. Now, looking at what happened, so now this law is on the books, and this board may know that why we have standing here today is filed a conditional use application. And that conditional use application will go to your elected officials, and they will decide it. But what is the ordinance in question? How do you look at it? So this is important because this is when you come up with an arbitrary number for a setback, for instance, And you see how rigorous it is to objectors and the effect that number has going forward. So a conditional use, like special exceptions that your board would see, is not an exception to municipality zoning ordinance. It's a use which applicant is entitled to as a matter of right, unless the municipal legislative body determines the use does not satisfy the specific criteria. An applicant who satisfies his prima facie burden is entitled to approval. In a proposed use, unless objections show that on the credible sufficient evidence, the proposed use would have a detrimental impact on public health and welfare. In any case, and this is the case from Jefferson Hills that myself and Mr. Lucas argued, in any case, it is well established that the facts that a use is permitted as a conditional use evidences a legislative decision that the particular type of use is consistent with the zoning plan, presumptively consistent with health, safety, and welfare of the community. The proposed use enjoys the presumption is consistent with municipal planning objectives and in public health, safety, and welfare. This is so because the governing body, in enacting the ordinance, presumptively took into account the impact of the use, considered it not to be a threat to health, safety, or welfare. That did not happen when this was adopted. They don't know. So when we go forward, that is what an objector is stuck with, that the court is going to give the benefit that everything Murrysville did is protective of public safety and will not look behind what they did. That's the purpose of this board, and that's the purpose of this challenge. Look behind what they did. Are they entitled to that presumption that the ordinances took into account the impact of the use, considered it not to be a threat to health, safety, and welfare, when they looked at no air modeling, they looked at no chemicals, they looked at nothing as to whether if the water is affected, how long it would be affected, where it would go. None of that is part of the public record. They looked at how can we accommodate drilling and not get sued. That's the basis. That was not consistent with their obligations under public health, safety, and welfare. As we're almost here to the end of this, the other thing that we mentioned earlier is the violation of Article 3, Section 32. When we challenged Robinson, we challenged various portions under Article 3, Section 32, and that is our special law section of the Constitution. That is our equal protection clause, essentially, that you can't treat one industry, one person different. You can't create a law just for me or for anybody in this room. Here, and if you do, you violate special laws. Now, the next slide, I'm definitely not going to go into. You'll see the length as it pops up. But essentially, this is the backdrop for the board displaying how this constitutional amendment came about, where the railroad industries are getting favorable treatment all over Pennsylvania. And Pennsylvania had to step in and say, you can't just craft laws that benefit one particular industry. In this vein, the oil and gas industry is the only industry in Murrysville that is allowed outside of the industrial zone, is the only industry that has its overlay district that can circumvent zoning, is the only industry that is looked upon to make money instead of public health, safety, and welfare. And lastly, oftentimes we get, and the Allegheny Court is no different in the Commonwealth Court, that, well, making money is a good thing too. And absolutely, I'm not here to tell people that they shouldn't make money from oil and gas. What we're here to say is that there is a constitutional way to do it, and this isn't it. But unfortunately, sometimes courts, sometimes boards, and sometimes residents look at the economic features. And you know, is sitting there, I don't know where any of you live, but I will assure you that you can make more money in your house if you could do a McDonald's or some other business, but you're not allowed to do that. Zoning is not about how much money you can make. It's about separating uses and protecting people from harm. But here, the recent decision in Allegheny Township found that in Robinson, the plurality recognized that development promoting the economic well-being of the citizenry obviously is a legitimate state interest. What the court did is somewhat of a disservice. They didn't go on to say the but. And the court went on to say, but to achieve recognition of environmental rights enumerated in the first clause of Section 27 as inviolate necessarily implies that economic development cannot take place at the expense of unreasonable degradation of the environment. The Pennsylvania Supreme Court held, and remember, in this vacuum, in this area, that the argument was advanced by the state, the same argument may be advanced here, that we want people to make money, and that if we allow them to drill, they will make more money. And the court rejected that. And the court held, if economic and energy benefits are the only consideration at issue, this particular argument would carry more weight. But the Constitution constrains this court not to be swayed by counter-policy arguments where the constitutional command is clear. No principle of law permits us to suspend constitutional requirements for economic reasons, no matter how compelling those reasons may seem. Murrysville suspended the principles of law for economic reasons. Here is just a slide of the overlay. And when we get into the evidence that we set forth, you will see how these laws play out, how the Constitution was violated on many fronts, and how Murrysville can do a better job. Murrysville did what a lot of municipalities did. They did their best. Unfortunately, when you expose 33% of the municipality to industrial activity, when the purpose of that district is to provide safe places for people, it looks not to condone, but to keep out the same activity you've let in, and you've not undertaken any sort of scientific study, you've not looked at any literature, and you have no idea whether any of my clients or any other residents, due to topography, wind conditions, or any aspect of the municipality, will be affected by the zoning or by allowing drilling. You've not done your job. Thank you.
Of Murrysville, acting as special counsel, and I acted as special counsel to the municipality and enactment of both ordinances that were referenced here tonight. One of the fundamental problems with the entire framework that was put forth by Mr. Smith, while he gave lip service initially about the municipality trying to do its best in looking out for the residents, is it's always one-sided. You have to only protect any resident against any impact. What that ignores is the overriding, the fundamental constitutional tenet that's here, and that's we all have property rights. I don't want to get too dramatic about it, but that's what the country was founded on, being able to use your property. Zoning is an application of police power. Those are very, very powerful words. It's become where folks, and a lot of the folks behind me, some of the folks I've even lived with, think that that means I don't like what my neighbors are doing, or I'm impacted by my neighbors, may impact my property values, that somehow I have a right to protect that. And it's just, I've had a difficult time practicing for 35 years and saying, look, the framework is the reverse. We have a right to do everything. The government's coming in and saying you can't. And that's supposed to be taken very seriously. Now, when we say you can't, that has to be in ways that we understand, or not just giving anybody the right to make money. These are fundamental rights of people to use their property as they see fit. It may be survival. It may be the survival of the farmer. It may be decades, families, generations of people that are trying to have a livelihood and save their families. I don't have any problem with being an advocate. I have a problem when it gets personal and it's characterized. And there are good people on both sides. And we don't want to chastise anybody that might be in favor of this as somebody that's just money grubbing. I've had the privilege of representing Murrysville. It's a developing community. There's always been discord as to whether there's growth, not growth. It's always taken in good faith and trying to do the right thing. It's the only reason I've stayed here. I don't represent many municipalities. They did that in this case. The law, the Constitution, is that we balance the interests served. We have to balance the protections against confiscatory nature of exclusionary zoning, and we have to look at the impact. This is about impact. The other fundamental thing that I have that's problematic about Mr. Smith's presentation is he keeps saying, you're going to hear, or you won't be able to tell them how, or you have to ask, how did they do it? No, there's a very, very strong presumption of constitutionality. We have elected officials. There's a ballot box if you don't like what they're doing. You do not intrude on that process. They have a strong presumption that they're acting in the best interest. So it's their burden, a very, very heavy burden. You won't be hearing a lot of this. We need to hear from them. What is it that's problematic? This challenge is that the regs must establish against a very strong presumption that the regulations are arbitrary, unreasonable, and unrelated to the public health, safety, and welfare. And I can tell you, if these folks win this case and find that this ordinance is arbitrary, unreasonable, and unrelated to the public health and safety and welfare, then the cases that Mr. Smith conveniently didn't reference that have now dealt with the basic tenets that he's referred, and it sounds good when you talk about protections and environment, but there are cases now. I'm not going to step on Mr. Lucas's toes, and I'm not going to extend this because I don't want you to be bored. I'm sure you'll hear from the industry about how the court has actually applied and is applying these cases. If this ordinance fails, none of these will be. Where we're going to get in this case, they're going to essentially have to show, there are two issues here. And I'll get to the second one, and I'm glad that Mr. Smith has at least recognized the fact that an overlay district is a valid tool in land use. Believe me, it's, I've been challenged and been asked out here even many, many times. So we at least think it's a valid tool. He's going to allege we didn't use it properly. But essentially, they're going to have to show that you can't drill in a rural residential or in a low-density residential district. That's the case. You have to say, hey, this is industrial, and it's incompatible. Well, this municipality and many others, you essentially have to exclude them. And that's, whenever we looked at this, we had to fundamentally decide. Now there's this question, oh, are we worried about challenges from the industry? They don't know the people that live out here or elected out here, and they certainly don't know me. We're trying to do what's right, and we'll respect whatever the courts find. But we have no problem standing up and saying this was a good faith effort and it's far from being arbitrary or unreasonable. The reality is that it's a legitimate land use. It's new in the sense that it's the type of drilling. The drilling's hardly, when you look at the logo for the municipality, 1878 first commercial gas well. The things that are nuances different, more impactful, admittedly, but hardly brand new. And it's not that we don't deal with new things, whether they're drive-throughs or communications towers or medical helicopters. We do them regularly. And it's how do we do them? How do we do them responsibly? Or do we say, we shouldn't do them at all. We're going to exclude them. Not being afraid of them, but again, in protecting the residents. If you're wrong about that, the challenger has broad swath to then do things that you otherwise may have been able to protect. So that's what we're trying to balance. It was always trying to balance, how do we reasonably respect this right? How do we legitimately provide for the land use and do it in a rational and responsible basis? We'd like to hear it. They can present all their experts or do whatever they want. We're willing to stand with this ordinance versus the cases that are in the courts. Again, I believe this court is a preservation of the overall tenet that you can't put unconventional wells in a rural or low-density residential district. There's really no other way they're going to win this case, because if they lose the cases they've lost already based on Robinson, there's no way they win this case. So they basically have to hit a home run in the Supreme Court, more than a home run. It's a grand slam, triple crown. They have to have the Supreme Court say, you just can't drill in a rural residential district to win this case. And if that happens, that happens, so be it. But we didn't think that was the fabric of the law while we're going through this process. And let's go back. There was some history, and there were some things imputed about the history. One, the initial ordinance was enacted pre-Act 13. The framework on which we did it was based on essentially the framework of the law now. This whole preemption idea in Huntley and Oakmont, that wasn't any surprise to people that do land use. The term preemption is very, very rarely used in land use. And God bless the industry was trying to get that, an extension of the Oil and Gas Act to do that, but that was no surprise, and we never here believed that the Oil and Gas Act preempted unconventional drilling. As a result, however, it was coming. We knew it was there, and we tried to anticipate it and do it in a responsible way. Well, then Act 13 came in. As John indicated the municipality wasn't in favor of it. And so it basically sat tight, and as it wound out, went through the courts, Judge Pellegrini's decision in Robinson 1 had to look at it again, but the ordinance that then is currently under challenge didn't establish the essential framework of the overlay district and where the wells belong. It did look at and consider the evolution of the industry. You know, things were happening. And it doesn't matter whether they were actually considered, whether they were wrong, and we're not going to get into that. That's up to them to challenge. The intent, or whether the council was right on that or not, but whether they were the length of laterals or the provision of water, this was all changing, and so it's a look. What this municipality looks at appropriately is they don't do a one and done ordinance. They continue to look at things. And it's a living, breathing document. It's a living, breathing law. And there may be future amendments. They're going to have to adjust the case law, not just this challenge, but future case law and the industry itself. That's what really happened. It wasn't so much an adjustment to any of this law, because frankly, the law's coming out where we always anticipated it. You need to provide for legitimate land use, you need to do it in appropriate places, and it needs to make some sense from a zoning, classic use and use restriction situation. The overriding interest in Murrysville, as has been enunciated, is the protection of residential property values. Murrysville, and I think at this point we only intend to call one witness, and we may not call him if he's called first, but Jim Morrison's going to testify. And you'll probably hear Jim say this because I've heard it over the years. Murrysville rises and falls depending upon the residential property values. And it is almost entirely residential, so you had to choose really lower density residential versus high. That was the challenge. And to give you an idea, and some of the things that you'll hear later, and all you're going to hear, you're not going to hear about intent, you're not going to hear about factors that were considered, you're not going to hear from us, and you're going to hear me object repeatedly. In fact, you'll hear me object after the opening in terms of rationale. None of that matters. We have an ordinance, and it has four corners, and the question, is it or isn't it? Doesn't matter if good intent, good judgment, bad judgment, it's the result. And we stand on this result. What you'll see whenever we get to the maps, because you hear, 33% of the municipality is technically, allowed. Well, that's the overlay, but you have to do that in conjunction with other provisions and other restrictions. Applying only one restriction, that's a separation requirement. You get down to less than 6% of the municipality. There are other ordinances, slope ordinance and things that further restrict it. So very, very little of the municipality can actually be drilled. The overriding factor was how many residences, how many households are you affecting when you do this? And when you do it and you look at the scheme, are you effectively allowing for the use of the property rights and the implementation of this legitimate land use? And to just give you an idea, there was some allusion to the fact that in the business district, which is very limited in the municipality, but if they were allowed there, that's more compatible. What you'll see is if they were allowed there, they would impact 5 times the number of homes on a density basis than they do where they are now. So that's the kind of overall legitimate scheme we were looking at whenever you do the overlay district and find out where they could be separation district and how many households that you're actually impacting. So there was a very strong rational basis for it. It will stand on its own whenever the courts look at it. It's not really a fact-based. These are questions of law. So you may receive a lot of opinions, but there's going to be very little fact-based testimony, and to the extent it's taken, we're going to object strenuously in order to keep this a tight record. We think that this board, Common Pleas Court, Commonwealth Court, ultimately the Supreme Court possibly, can look at this ordinance in the context of other ordinances. And this ordinance stands very well against all of that. In fact, it's common that it's used as a template by other ordinances, other municipalities that are looking to be very responsible in regulating unconventional wells. And with that, turn it over to Mr. Lucas.
I'm going to defer to Mr. Matthews here first.
Good evening again. My name is Bernie Matthews. I represent several of the property owners that have leasehold interests with Huntley. And I think a lot of the time in these hearings, I've done these for 31 years. The residents come and they think, what the zoning board is going to decide tonight is you're either for drilling or you're against drilling. And as you know, that's not what you're going to decide in this proceeding. And you know, the time I think for making legal arguments is in the traditional trial sense. Once you've heard all the evidence and you conclude the case and you make your legal arguments, and typically in front of a zoning board, we do that with written briefs. But I'll briefly respond to a few of the things that Mr. Smith argued, because I think it's important for you to hear, particularly some of the more recent developments in the law that are going to guide your decision in this case ultimately. You've already heard reference to the Allegheny Township Frederick case. I serve as a solicitor at Allegheny Township, and Mr. LaProfido sat on was the solicitor to the Allegheny Township Zoning Board. So you have the benefit of two lawyers at least who were directly involved in the Frederick case from the start in front of the zoning board to the common pleas court and to the Commonwealth Court. And the Frederick case was decided on October 26, 2018. Here's the decision. It's a 60-some page decision. And I'm not surprised that Mr. Smith did not spend much time trying to distinguish the Frederick case, because the Commonwealth Court rejected pretty much everything that Mr. Smith told you tonight in the Frederick decision. That was a heavily litigated case. That was 3 or 4 nights of zoning hearings. There were plenty of fact-based witnesses and experts that testified. And the Commonwealth Court considered all of that in the context of this challenge. Allegheny Township's ordinance permits drilling in all zoning districts subject to compliance with a myriad of state environmental regulations and laws, and also subject to the regulations that are actually set forth in the ordinance itself. Allegheny Township is a rural, residential, and agricultural community. Not identical to Murrysville, but similar. I don't think Allegheny Township has quite the business district that Murrysville has along 22, but Allegheny Township has a small business district. But it is primarily agricultural, large tracts of land, residential properties. In Allegheny Township, in the Frederick case, and this came out in the hearings and as well as in the Commonwealth Court decision, the Board of Supervisors made the legislative judgment that larger farm parcels in particular were not only compatible with oil and gas drilling, but they could safely coexist with oil and gas drilling, and importantly, that oil and gas drilling in compatibility with farming or agricultural uses actually work together to preserve the agricultural nature of the community. So to the contrary, where arguments were made that you are allowing industrial uses to destroy our agricultural community, on the contrary, the evidence in that case, which is talked about extensively in Frederick, established that not only could they safely coexist, it preserved the agricultural nature of the community, because after the 6 to 9 month temporary disruption of drilling the well, the properties were restored and we were back to an agricultural use. The other thing that came out that was interesting in Allegheny Township is, you know, Murrysville and Allegheny Township have been targets for residential development on an ongoing basis. And it was interesting that, you know, the idea was, look, we see a far greater long-term impact to losing these farms because they can't drill and generate revenues from the drilling, to losing them to residential developers who come in and develop cookie cutter 50 lot subdivisions. And now we have roads, we have stormwater management plans and stormwater management facilities, we have sanitary sewer pump stations,
all of these long-term impact that put, strain on the resources of the community were considered versus a temporary disruption from the drilling of a well, that once you restore the property, all you see are some facilities that continue the operation. What we hear over and over again in these cases from the objectors to oil and gas extraction is that oil and gas extraction is an industrial use, and that can only be permitted in the industrial district. Now in Murrysville, I take it, I understand you don't have an industrial district, so they want it to go in the commercial district or the business district. Contrary to what you heard from Mr. Smith, in its most recent relevant decision in the Gorseline case, the Pennsylvania Supreme Court stated in reference to Robinson and Gorseline, two cases you're going to hear about ad nauseum, quote, "Our decision should not be construed as an indication that oil gas development is never permitted in residential agricultural districts, or that it is fundamentally incompatible with residential or agricultural uses." End quote. Now why is that? Because each community is different. That's why each community decides for its own self, what's our comprehensive plan, what is our zoning scheme, and what works for our community. So relying on that statement in Gorseline, the Commonwealth Court in Frederick upheld the validity of Allegheny Township's ordinance, which allows drilling in every zoning district. Because it looked at the evidence, and it looked at the specific circumstances of Allegheny Township, and it said, look, what's right for Allegheny Township may not be right for the city of Pittsburgh, may not be right for more dense communities. But when we have this low-density agricultural residential community, it is compatible with the evidence and the circumstances in that case to allow oil and gas drilling with agricultural and large tract residential uses. The other thing that's important is, even though in Allegheny Township, as a practical matter, once you apply the myriad of setbacks and other regulations at the state level and even at the local level, you end up with a substantial part of the township that is ineligible for drilling. And as Mr. Siddick just pointed out, I was surprised to hear that it actually gets down to 6% in Murrysville. I mean, that's a pretty low number. It was higher than that in Allegheny Township. And in the Commonwealth Court, they said that's fine. So, as has been pointed out by Mr. Siddick, if the Commonwealth Court upheld Allegheny Township's ordinance, which is less restrictive than Murrysville's ordinance, then Murrysville's ordinance is valid as a matter of law, period. And they can present all the evidence they want, but right now the state of the law as of October 26th is Allegheny Township's ordinance, which is less restrictive, is valid, therefore Murrysville's ordinance as well. It's also left to the judgment of, or the legislative judgment of Murrysville to determine for itself where oil and gas drilling should occur. It is not true as a factual matter that oil and gas drilling and extraction is incompatible per se as a matter of law with residential and agricultural uses. It just simply isn't. And there was a myriad of evidence presented in Allegheny Township explaining the history in the Commonwealth of Pennsylvania of how oil and gas drilling and uses have safely coexisted with the use of agricultural property for decades. I also want to point out what I think to be the fatal flaw underlying this substantive validity challenge and all the others that are similar to it. And this fatal flaw, I think, shows that the challengers will never be able to overcome this argument no matter what evidence they present. The municipality's planning code authorizes but does not require a municipality to adopt a zoning ordinance. There are 785 municipalities in Pennsylvania that have chosen to not adopt a zoning ordinance. 10 to 12 miles east of here, you have Salem Township that has no zoning ordinance. So, if you accept the argument of the challengers, every municipality that doesn't have a zoning ordinance, that doesn't regulate in any way, is violating the Pennsylvania Constitution. It's just simply not the case. It's not the law in Pennsylvania. It's simply counterintuitive to say, well, we have decided to actually go forward and restrict and regulate more so than the other 785 municipalities that don't have an obligation to do so. They're okay. They're not invalid. Their ordinances are fine, but ours is invalid because we actually did something. It makes no sense. It's completely inconsistent with Pennsylvania zoning law principles. The Pennsylvania Commonwealth Court, ironically, pointed out this flaw in the challenger's argument. Read the Frederick decision. The majority opinion says, look, if you don't have to have any zoning ordinance, why is it that when you go forward and take the step to restrict it, that somehow is substantively invalid? It makes no sense. In Pennsylvania, as has been pointed out, substantive validity challenges are based on the premise that an ordinance goes too far in regulating and restricting a use, and therefore is arbitrary and capricious. It's not based upon the premise that you don't go far enough. All of these challenges we see are typically based on the idea, hey, you're regulating my land use in a way that prevents me from using my property. That's the premise of a validity challenge. I'm not aware of any validity challenge case in Pennsylvania where the court said, your ordinance is invalid because you didn't go far enough. Not aware of a case. Fundamentally, and I'll conclude with this, fundamentally, if a landowner, and my clients are landowners, if a landowner in Murrysville owns valuable oil and gas rights, and that landowner wishes to lease or develop those rights so their family can keep their farm, so they can send their kids to college, and the development of those oil and gas rights that they have maintained for years complies with all of the state environmental regulations, and there are many, and we'll show you all those in our brief. It is not the role of government, it is not the role of zoning to prevent the landowner from doing so by limiting extraction of oil and gas to an industrial district, which in Murrysville is nowhere. Murrysville ordinance has a number of regulations and restrictions that frankly I think many oil and gas drillers find objectionable. And I think they probably find it objectionable that only 6% of the community can be drilled. But they work within those restrictions, they comply, and they obtain their permits, both at the state and local level. We think Murrysville's ordinance balances the public health, welfare, and safety of the community. Mr. Siddick explained the long process that they went through to do that. We think it balances those interests with the property rights of the landowners, and we think it should be upheld.
Here on behalf of Huntley & Huntley Energy Exploration, LLC. My co-counsel is Paul Burke, the general counsel, who wanted me to point out he is also a resident of Murrysville. We're tallying up numbers here, which kind of makes us all feel old. I heard 31, I think they're 35, we're 37, right? So do we win on numbers, or we just go home? The authority for zoning lies in the first instance with the elected governing body of the municipality of Murrysville, and that, in this case, your municipal council. As the elected representatives of the township or the municipality, they're responsible for setting initial public policy. Here, as I think it's been alluded to already, and there will be more testimony on, the municipality went through a very lengthy process leading up to the adoption of the ordinance that's now being challenged. Challenges argue ignoring both the historic and present coexistence of oil and gas development with other uses, that oil and gas can't be located in the same district with other residential or agricultural uses and must be limited to, quote, industrial districts, the magic word industrial, although, as has been pointed out, Murrysville doesn't even have an industrial district. If that argument's accepted, it's likely to effectively ban oil and gas development in the municipality of Murrysville, and it will also deprive not only my client, but Mr. Matthews' clients and the scores of other leaseholders in the municipality of of any economic value of their oil and gas rights. The frustrating issue here is we're already hour and a half in to what's probably going to be multiple nights of hearings. This issue has been litigated over and over and over again over the last 2 or 3 years. And there's been a reference to the Allegheny Township case, and I'm going to circle back on that in a moment, although Mr. Matthews did steal a lot of my thunder in that regard. In all these cases, zoning hearing boards and up the chain courts, up through the Commonwealth Court now, have consistently rejected the exact same argument you've heard here tonight. You start with the basic principle, though, again, once this ordinance was adopted by your municipal elected officials, it's presumed to be valid, and the municipalities' councils touched on that. Case law is very clear that there's an extreme burden on those challenging the ordinance if they want to overcome its validity. In short, it's really not enough to say out there, hey, we might do things differently, we might bring in engineers, we might bring in planners, they might have a different opinion on what the ordinance should say. That's the legislative judgment of the municipal council, and it's a very high burden for anyone to challenge an ordinance, whether it's on oil and gas or anything else, as being invalid. It's not the role of the courts, it's not the role of the zoning hearing board, it's not the role of the objectors to substitute their judgment for that of the municipal elected officials. Now, we've heard a lot about the Robinson Township case, and I think that the members of the board are probably somewhat familiar with it, as well as most of the public. And that did involve the invalidation of some provisions in what's called Act 13 that limited the authority of local governments to regulate oil and gas uses. Ironic, I mean, that case was brought. Now, I would disagree with the characterization that Attorney Smith gave, that this was brought to preserve some noble environmental goal. That case was brought because his client and other municipalities were none too happy that their regulatory authority had been limited by the state legislature. The irony of all this now is you'll see that very same argument being turned 180 to now basically try to take away authority from local governments. And again, I alluded to, there have been at least 9 cases over the last 2 years been filed, very similar to the one you have here. Universally, those cases have rejected on the merits the arguments you've heard here. And a couple have also rejected on procedural grounds, standing and ripeness and those kind of things. Those are Allegheny Township, Westmoreland County. Even more recently, Penn Township, Westmoreland County. Middlesex Township, Butler County. Mount Pleasant Township, Washington County. Cecil Township, Washington County. And Pulaski Township, Lawrence County. And they've all gone with various steps up the judicial chain. The most notable, and again, Attorney Smith only alluded to it in passing, is the Allegheny Township case. In that zoning district, and I have to summarize and not try to repeat everything that Attorney Matthews said, that ordinance permitted oil and gas use as a permitted use by right. No public hearing, no special exception before the zoning board, no conditional use before the governing body. Just as an administrative use by right, if the requirements of the ordinance were met in any zoning district in the township. We were involved in that case, presented a lot of the evidence that Bernie Matthews refers to, dealing with the historic compatibility of oil and gas, the expensive regulatory regime that occurs at the state level. It's not a question of, oh, the state regulates it so you don't have to do anything, but you don't have to repeat everything that the state does either. That zoning hearing board, after multiple nights of hearings that your solicitor can attest to, found the ordinance to be valid. President Judge McCormick, then President Judge McCormick of the Westmoreland County Court of Common Pleas affirmed that decision. And then just last month, the Commonwealth Court en banc, the whole court, affirmed those decisions and found it to be valid. And in doing that, they rejected the due process argument you heard raised. They rejected the environmental rights argument you heard raised. They specifically rejected the exact arguments in the same sections of the municipality's planning code that you heard raised. So that is the binding law right now of the Commonwealth. Similarly, there was a similar challenge in Penn Township, and that was recently heard by Judge Smale, and after 4 full days of hearings, that ordinance was also affirmed. That ordinance also had an overlay district, which covered more of the township than your overlay district does here. It also had lower setbacks than what your ordinance does here. And Judge Smale found that that ordinance was also valid. Critically, there's been some reference to Robinson Township and to the PEDF case and what obligations that placed on municipalities such as Murrysville. Both those decisions were decided after PEDF. They were also decided after the Gores Line decision. And as Attorney Matthews quoted from, the Supreme Court in Gores Line said compatibility is that they're not finding that oil and gas is incompatible with residential and agricultural uses. And I've given you copies of both the Frederick and Penn Township cases as well as the Gores Line decision. The only thing I've tabbed is precisely the quote that Attorney Matthews read, that basically provides that municipalities are free. I'm going to read it again because I think it's really important. In so ruling, this decision should not be misconstrued as an indication that oil and gas development is never permitted in residential agricultural districts, or that it is fundamentally incompatible with residential or agricultural uses. To this end, the municipality's planning code permits the governing body of a municipality to amend its zoning ordinance to permit oil and gas development in any or all zoning districts. The governing body must, however, actually amend its zoning ordinances to permit drilling in designated areas, setting forth what other limitations and conditions it decides are appropriate for the protection of its citizenry. We would suggest, I understand there's several lawyers on the board, we're in a different setting, but if we were in court, we would be asking for summary judgment as a matter of law at this point. And I would also point out, we representing Huntley and other companies in the industry and monitoring this closely, we've looked at hundreds and hundreds of ordinances in southwestern Pennsylvania regulating oil and gas. I think it's fair to say yours is one of the most limiting, maybe not the absolute most, but it's probably in the top 10% in terms of restrictions and requirements it places on the oil and gas industry. So if this ordinance is invalid, virtually every other ordinance in southwestern Pennsylvania is too. So again, we think this is almost a matter of law. I guess we are going to have hearings on a few things with some factual testimony, and we'll be prepared to provide some testimony in that regard, probably consistent to some of the evidence that was presented in the Allegheny Township case. Thank you.
Members of the board, as you're aware, these are opening statements. They are not substantive facts. They are merely outlines and case law recitations for your benefit. I believe that at this point, though, the parties do have a legal argument to present to the board on an issue of substantive testimony. Is that correct, gentlemen?
On the subpoena issue?
Yes, on the argument with regard to.
I'm sorry,
Is that on the intent issue?
it's okay. The subpoena that you're on, do you want me to play first or you want to, I don't care.
Well, I have no problem doing that. It's really the municipality's position on, the subpoenas have been issued, they've been served, and now it's the municipality taking a position that the relevance of those witnesses and testimony that elicited, that there isn't any in this proceeding, and that they shouldn't appear, nor if they appear should they have anything to testify about. I did prepare a memo,
Which I received earlier today.
I did circulate that to the board late in the day today. I'm not sure if you had an opportunity to review it.
And Council, correct that you circulated my
I did.
letter? Okay. Don't want to give you more paper than you need.
Certainly two current sitting council members and two former council members who were acting whenever the ordinance that's being challenged were sitting.
It should be noted for the record that at the request of Mr. Smith, the chairwoman did issue the subpoenas in conformity with Pennsylvania law. This argument is merely as to the issues with regard to the testimony, not whether the subpoena should have been issued.
I will state, and these aren't something taken lightly as an officer of the court. We follow the rules, subpoenas are issued. We expect that in terms of the legal process to be really inviolate. In fact, it's with precisely that in mind that we're taking this position. And with all respect to the board, believe me, as somebody who sat in your position for decades, they're not going to testify. And we're willing to have the court decide that and to preserve that issue. And there's no question, and I don't want to not preserve the issue as whether it's relevant or not. But at least as far as it's been enunciated now, and I asked the protest appellants to enunciate their grounds, essentially they want to talk about the ordinance and how it was enacted, what was considered, and at least at the end of their argument that they tried to make a distinction that the Environmental Rights Amendment somehow creates some trustee capacity, which now gives them the burden to establish that they're protecting public and acting in that capacity as trustee. It is, in fact, when we were on a phone call earlier, I had indicated to all council that I'm not even going to, I'm just going to make this, it just needs a common sense, that we can't have legislators come before the judicial body to talk about what they did. The law is very clear. It doesn't matter how they got there or even what they thought or didn't think, it's just a result of it. So no matter what position any individuals took or they took collectively as a body or the process that they took, it couldn't be more clear. It's Hornbook law. It's not relevant. It can't be relevant. There are no facts based on their deliberative process that could in any way be relevant to this process. It's because you have to look at what they did, not how they did it, not what they considered. In fact, what we actually heard in Mr. Smith's argument earlier is we'll tell you what council members heard during the numerous hearings that were taken in connection with this ordinance. That's exactly what we're not going to get into is the process of enacting the ordinance. So what I've advised, I have spoken directly with two of the individuals, but my memo has been circulated to all the individuals, and I advise them to not appear, that the remedy may be that we may be wrong, and if the court wants a remand and wants to hear their testimony, that's fine, but that in no case can legislators be called before a zoning board to talk about the enactment of an ordinance.
The board, please. My name is George Kodgeroffis, and I'm Murrysville's General Solicitor, General Counsel Solicitor. I'm joining with Bill Siddick today in opposing the issuance of those subpoenas and the testimony of the board members for the same reasons.
During my presentation, I walked through a number of cases that are controlling. Those of you that are lawyers or those of you that follow the law know that the Pennsylvania Supreme Court has the last word on these issues. The Pennsylvania Supreme Court in Robinson and PEDF are the controlling law of the land. The Allegheny Township case is a Commonwealth Court case that's been appealed to the Pennsylvania Supreme Court. In the past couple of years, am I going to sort of pass you? Okay, I'll slow down. That's fine, just tell me, that's fine.
Just slow down a
I'll do my best. There have been a number of cases that have gone up from the Commonwealth Court. PEDF, they overruled the Commonwealth Court. Gorsaline. They overruled the Commonwealth Court and said that drilling in a residential agricultural area in that particular municipality was not allowed. It violated the Constitution. And they didn't look at the, they didn't look at the Constitution. They looked at whether it was comparable to the uses that were there. It was overturned. The Commonwealth Court has done, and there were two dissents. I think counsel misspoke. He said the whole court decided the Allegheny Township case.
Excuse me, I'm sorry, I don't mean.
I'm gonna get to my point.
Interrupt you, but I'm gonna ask for the purposes of this, that it's not a rebuttal as to their openings, that this must be related specifically to the argument of the relevance of the testimony under subpoena.
It is, and I'll get right to that. I would apologize, counsel, because the backdrop to that is the understanding as to why it's relevant. Because the Allegheny Township case, which is a 5-2 decision with 2 dissents, that has been appealed to the Pennsylvania Supreme Court. We're looking at the case law, the PDF that I cited to you in my letters. And the trustee obligation that the Supreme Court of Pennsylvania, not the Commonwealth Court, that's been overturned on numerous occasions, the Pennsylvania Supreme Court has held the obligation of the Commonwealth as trustee has certain obligations. We are not, and I've told Mr. Sittig this, we are not interested in the intent of the legislature as to why you did it. Did you favor one interest over another? That is not a proper question. That's the case law that he cites, and I agree with him. The intent of the legislature, why they did it is irrelevant. I'm not looking for why they did it. I'm looking at, in order to prove that the ordinance that carries that weight at the next level, that it is presumed constitutional, that it is presumed that they took into consideration the public health, safety, and welfare. I want to know, I'm sure everybody wants to know, what did those elected officials look at to make that determination that the law finds so compelling that they did their job as to public health, safety, and welfare. So if they say on the record at their hearing, we looked at nothing, I can't elicit that testimony, that the number of 750 feet setback is based on a pure negotiated effort, not based on anything to protect the public health, safety, and welfare. How am I to prove to my residents who are stuck with, at the conditional use level, the idea that the municipal officials acted to protect their interests, if the municipal officials don't testify what they looked at? They should be able to stand up and say, here's what we looked at. I represent municipalities. My municipal officials, they would know what they looked at when they created an ordinance. They could take the stand. Not why they did it. I don't care why they did it. Their vote is in, their vote is public record. The trustee obligation, and I cited trust law, that's in my brief, and that wasn't rebutted by Mr. Sittig. He doesn't take issue with in his finding. I'm sure he does orally. But he doesn't take issue with the idea that there's this trustee obligation. When you look at the Robinson decision, the court walks into trust law. It walks into the trustee, which is Murrysville. And under the law that I cited, that our law is well settled, that evaluating the propriety of a trustee's course of conduct requires consideration of the terms of the trust, the nature of the power accorded to the trustee, and all the circumstances surrounding the trust. Finally, if a trust investment, and I bracketed ordinance, is properly questioned, the burden of showing the wisdom or propriety of his conduct in making it is on the trustee. That is what we're looking at. And when we appealed to the Pennsylvania Supreme Court in Allegheny Township, one of the issues that we raised is that this is the only constitutional amendment in Pennsylvania and in the United States that applies to Pennsylvania that creates a trust obligation, specifically in the Constitution. The court has unequivocally said that Murrysville has the role of trustee. The trust law then is implicated. They have the ability to take the stand and testify what information they utilize so that my client can say, well, I am protected, I am safe, because that's what the law is presumed. And if they take the stand and testify they looked at nothing, then that is your job to say they didn't do it. It's pure arbitrary. That's why their testimony is relevant. Thank you.
Can I also chime in briefly?
I really am going to step in, because one of the things, again, getting out of line and getting personal. Frankly, don't care what Mr. Smith's clients would stand up here and do. I have no question with all these individuals who have gotten to know in their capacity would be truthfully able to elicit what their thought process was. It's offensive to insinuate that the people that represent this community wouldn't be able to do what elected officials in his communities have done, somehow because, you know, they're better people. He is pointing out exactly why we don't go down this path. It is irrelevant whether and what they took into account. It is what it is. It's the result of it. And it couldn't be clear what Mr. Smith is asking you to do. He doesn't cite any case. He acknowledges my cases are all good. He can't cite a single case in the Commonwealth or in the United States where the judicial body was successful in subpoenaing a legislature. He's conjuring up, and he gets to preserve it. If he's right, he's right. But he's conjuring up this environmental rights amendment that the folks that were elected have this trustee obligation or this burden, and that they actually have the burden of proof to come and establish it. The Frederick Court, and I do note it, it's in my memo, has said, in the context of the zoning ordinance, you know, this isn't the only thing that the council acts on. They have police powers, there are general ordinances, there's a saldo, there's different ways to protect. But in the context of the zoning ordinance, the Environmental Rights Amendment, they don't have to establish their trusteeship, and we don't have the burden of establishing it. It's just not wrong, it's just not right. And to say, oh, we're going to have the Environmental Rights Amendment exception to subpoena elected officials to appear before a quasi-judicial body, it's not been upheld, it isn't sound legally. And all we're saying to, if he ends up being right and the court says that we need to do that, we will do it. But as of right now, the framework of the law is, this doesn't happen, it's never happened.
If I could follow up on Attorney Siddig's points. First, we concur with the township's position.
Sorry, what's your name again, sir?
Sorry, can you hear me?
What's your name again?
Blaine Lucas, excuse me. B-L-A-I-N-E-L-U-C-A-S. You know, unless there's some kind of ambiguity in the ordinance or statute, you don't get into legislative history. You don't get into what did the particular legislative think or not think. You know, Murrysville Watch's position here is pretty clear. They claim that this ordinance is invalid because it allows oil and gas development in parts of the RR zoning district. That's their claim. That's a black and white concrete thing, following up on part of Attorney Siddig's opening statement. It's either valid or it's not valid. They mention and argue, I counted at least 20 times in their validity challenge, that that's their beef, that you're allowing oil and gas in parts of the RR rural zoning district. What a particular council person thought or didn't think or was motivated by in reaching that vote is completely irrelevant. The burden is on the objectors here to establish and meet the high burden that that ordinance is unconstitutional. There was an allusion to the setback requirement. Well, I want to know why you picked the number you did. I would suggest, I think the law is pretty clear. The burden is on the objectors to establish why that setback requirement is unconstitutional. It's not up to the municipality to explain why they selected the setback requirement they did. And finally, I would just like to comment, I know you don't want to get back into the opening statements here, but the current status of the Allegheny Township case, on Monday, the last day you could do so, at about 4:30 in the afternoon, Attorney Smith and his client filed what's called a petition for allowance of appeal with the Supreme Court. The Supreme Court hasn't even decided whether they're going to take that case or not. And significantly, and the case I'd like to cite is Germantown Cab versus Philadelphia Parking Authority, 27 Atlantic 2nd, 280, 2011. This is Supreme Court. It's it's the Commonwealth Court. It's axiomatic that a decision of an appellate court remains binding precedent even if it has been appealed unless and until it is overturned by the Pennsylvania Supreme Court. So speculation that, oh, the Supreme Court might overrule Frederick doesn't matter. It is the binding law of the land now. And that gives the merits of her case, but I think also is relevant to the subpoena issue. Thank you.
Can I respond, Counsel? First of all, again, the PEDF in Robinson is the binding law of the land, and the issue is whether the Commonwealth Court followed it. So the Supreme Court sets the law. But here, remember, the issue and the standard that my clients have to prove is that the zoning ordinance must be arbitrary and unreasonable and have no substantial relationship to public health. The way for us to prove that it's arbitrary, is to understand what they looked at, not how they made their decision. The case law that's cited to you goes to intent. They don't care about the intent. I care about the information that was provided to council that they can look at and make that decision. Again, this is a situation where, because they have this trust obligation, and Mr. Siddick knows that I've cited trust law to you, and what I read you before was trust law that allows me to solicit this information. It may be a case of first impression for this board and for others that have never dealt with the trust power, because it's a relatively new area of law, because of the Robinson decision, because of PEDF, that we have this trust obligation. But how can I inquire as to whether the trustee violated their obligation until I know what they looked at? If in any other trustee situation, unless we're gonna look at new trustee law, the trustee every single time would have to take the stand and substantiate why they did X or why they did Y. I'm asking for the law to be applied equally and limited. I'm not asking for a fishing expedition. I want to take the stand and ask them very specific questions, what evidence they had to make their decision, so that you can decide whether the evidence before you is it in furtherance of the public health, safety, and welfare, or is their ordinance completely arbitrary based on whatever, that it's not significant, that they came up with numbers out of the blue. That's where I am.
Thank you.
Members of the board, if we could go off the record for a moment, I'd like to caucus with the members. Okay, the board is going to go off the record. We're going to go into the back room and caucus on the issue for a moment. Thank you.
The board has considered the request and the objection that has been made on the basis of relevance, and the board will sustain the objection on the basis of relevance. Mr. Matthews?
If I may, I wanted to identify an additional client that I'd like to represent and intervene in the case. It's Doris and Jurgen, it's Jurgen Eckberg.
Would you do that one more time, please?
Sure, will do.
Could you?
It's Doris, D-O-R-I-S, and Jurgen, Jurgen Eckberg, E-K-B-E-R-G. Their address is 6107 Ballin.
You're moving a little fast, Mr. Matthews. Let's start with the last name again, please.
I will do that. Did you get Doris and Jurgen?
I got Jurgen, yes.
So it's Doris and Jurgen Eckberg.
Only 2 dates for testimony in this matter. I circulated this earlier. December 20 at 7 o'clock p.m. with a limit of 3 hours of testimony. And January 24, 2019, commencing again at 7 o'clock with 3 hours of testimony.
During the council discussion on the phone, we talked about having a protocol for notice if any party was going to call an expert witness.
Yeah.
Is the board going to consider something along those lines?
Members of the board, there's likely going to be expert witnesses called by both sides on this. Given that the next hearing will be on the 20th, if there's expert witness testimony contemplated, I would propose that the appellant in this case would provide their expert witness list by a date certain with the appellees or interveners to have a period of time before they would need to supply their list of experts and their reports. Do you have proposed dates based upon the December 20th date for the next testimony?
Well, I think I'd have to defer. We don't know whether we're going to call an expert. It would depend on if and the nature of the expert testimony provided by the appellants. So I guess we're looking to the appellants council to identify, are they going to have an expert witness, and if so, when can they identify that individual and provide an expert report?
I I understand, that's why the board would contemplate the difference in time between the appellant's submission and the other parties. Mr. Smith, do you propose to call expert witnesses in this matter?
I don't know at this time because I have to evaluate, since the board just struck 4 of my witnesses, as to how I'm gonna fill that gap. So that's something I have to talk to my clients about. What I will tell you is, unfortunately, and I think Mr. Siddick may be in the same spot, that I cannot do December 20th in New York City at that time.
I'm in Elizabeth Township, but it's 6 p.m. here.
The January date seems to have worked.
Based upon the information I have from my board, those are the 2 available dates that we have right now. So we would have to defer the testimony then until January 24th. I'll solicit additional dates from my board, and I will circulate those so that we can have perhaps further expedited testimony thereafter. Maybe their schedules will open up a little more.
If it, as I understand now, our next hearing date is going to be January 24th, I think that's plenty of time to set a schedule for identification of any expert witnesses. I don't have any particular time frame in mind. I think Mr. Smith should be able to identify and provide an expert's report by the end of the year, and us 2 weeks after that.
Mr. Smith?
I'd have to think about that because, I mean, yesterday I think we were doing about 7 days before the hearing there would be an exchange of expert reports. Now it's 30 days.
Well, if
So-
you want to have a short, I mean, our problem is, we don't even know if we want to call an expert, and we won't even be able to determine whether we need to call an expert on rebuttal, locate an expert, and provide an expert's report. So that's why we need time in between.
Yeah, I agree with that, and I think there should be sufficient time. I'm just not in a position tonight to decide whether I'm going to call an expert or not. Let me talk to my clients based on the ruling. of the board.
Here's what I would propose. I would recommend to the board that the appellants would have until 3 o'clock on January 4th, 2019, to provide a list of expert witnesses and to provide their expert reports to opposing parties. And thereafter, then the interveners and the municipality would have until Friday, January 18th at 3 o'clock to provide their expert. That would give Mr. Smith well over a month and a couple weeks, and that would give the interveners and the township 2 weeks then thereafter.
And if we decide, for your purposes, and Mr. Siddick, if we decide who those are earlier and I can do it earlier, I will. Or if we decide not to call some of the experts that we're looking at, then I will let you know that as well. Especially with the holidays, I don't want anyone racing around for no reason.
Any other procedural issues that either of the parties would like to address?
Just one other thing, I don't expect a resolution of this tonight, but we would like to at least preserve potential objections to standing based on how far any of these individuals reside from the proposed type of plan. Given the lateness of the hour, I just want to get that on record. We just haven't heard enough information to determine whether we agree that we have standing or not.
I don't necessarily oppose that on any party to preserve issues. I believe that that is something that could be carried out better after testimony as opposed to right now, but I don't think that the board will take any action to preclude a notice on the record that you're preserving an issue.
Thank you.
That's fine.
Smith, you're fine with that?
Yeah, that's fine. I mean, ultimately, this is not a special exception before this board where we're looking at people immediately affected in terms of right next to these sites. These people live within these districts or next to the overlay districts. It's a question. And there's some more to that, but we'll leave it for another evening.
Given the fact that the next hearing is not until the 24th, I'm going to recommend that the board advertise another notice of the hearing, in addition to the public notice that's being presented tonight, just for the benefit of the public, given the amount of time that is, we're almost 2 months away from the next hearing at this point.
That is at 7 p.m.
That is at 7 p.m. here in this chamber.
And you indicated that would be 3 hours?
That's the intent. The intent of the board would be 3 hours of testimony that night.
And again, my intent is to obtain other dates from the board members after the 24th, and then circulate them to members, to council here, so that we can pick new dates.
We appreciate it, thank you.
Any other issues, gentlemen?